Welcome to LawHelp Australia, where we keep you informed and safe with tips and updates. My name is Dinesh Weerakkody. In today's program, we will focus on conveyancing. We've got a team here, an expert team. What is a Section 32 document? What is pre-contractual advice? What is the cooling off period? What is the subject to finance clause, and more? Let me ask Michael first. Actually, we should give an introduction. Michael, what's your area of expertise?
I'm a real estate agent, have been for 25 years. I'm also an auctioneer.
Rex, I've got Rex Afrasiabi.
Yes.
What is your background, Rex?
I'm a solicitor in commercial and property, and I've been doing it for over 10 years.
I've got Jan Rennick.
I'm a solicitor of over 30 years and I practice in areas of conveyancing, property, wills and estates law.
When we talk about buying property, house and lands or real estate, how do we start? What's the first step? Probably Michael will be the person to answer that question.
Once you find the property you want, then you've got to look at method of sale. Is it an auction? Is it a private sale? And there is a difference between documentation.
Right. So you start off by signing off the document, which is a contract.
In a private sale, yes. After an auction, you will sign the documentation if you are the successful bidder.
Right. And any other processes or methods?
Well, there's private sale, auction, and now they've actually brought in a new method, which is a type of tender. Set sale, fixed date sale, expression of interest sale, which is really a private sale with a closing date.
Right. Rex, is it, am I correct to say at the end of the day anyway there should be a document in writing?
Yes, there should be a contract of sale and a vendor statement.
Right. What is a vendor statement?
A vendor statement is disclosure by the vendor about aspects of the property, such as its zoning, restrictions on title, outgoings and the like.
It's compulsory, I guess.
It is compulsory. If you don't have one, the purchaser has a right to cancel the contract.
Right. Jan, can you give us an idea? Now, Rex, we've established that there should be a contract in writing. That's as per law. And there are certain requirements that the vendor must fulfill, like giving a Section 32 document. If someone signs a contract, before signing the contract, should they seek legal advice?
I think it's a very good idea to do so. Sometimes the circumstances may not allow time, but a conveyancer or solicitor can point out aspects of the property that you may not be aware of, like such as a covenant on the title, which may restrict you to only one dwelling when you might be intending to subdivide and put in two dwellings. It may restrict you in relation to the type of dwelling that may be built, etc. Those sorts of things that a solicitor would be aware of and would look out for.
Jan mentioned about conveyancers and solicitors.
Yes.
So the process is called conveyancing.
It is.
When does the conveyancing process starts, and what's the difference between the conveyancer and a lawyer?
A conveyance is a transfer of title from the vendor to the purchaser. The conveyancing process starts effectively from the time the vendor wants to sell. The conveyancing process can start because he prepares a vendor statement, a Section 32 statement. And it goes all the way until settlement, even after settlement when the title is registered.
Right, and what's the difference between and am I correct to say the conveyancing process is a legal process?
It is a legal process, and there is a difference. There's conveyancers and there's lawyers. A conveyancer is a TAFE qualified practitioner who just does the conveyance process, so it just deals with the transfer of the property, and their advice is limited to the transfer of the property. If anything else arises from that, they have to refer to a lawyer.
That's a good, interesting point. So does that mean conveyancing process is a legal process? Can conveyancers give legal advice within that process?
Within the process they can. Anything outside the process they can't. And a lot of times things arise from a conveyance that is legal issues, and they have to refer to a law firm.
And can you give me an example where it becomes legal, it's a requirement or required to get legal advice within that conveyancing process?
Just trying to think of one. Or maybe there may be a caveat that might cause problems, that a caveat on the title that has to be removed and it cannot be removed easily. Normally we would write to the person or contact the person, ask the person to remove it. They may say, no, we're not going to remove it. and thus we might then have to go to a solicitor to find out what the best way is to remove it, whether we have to actually go to court or whether there's some other, and that opens up other questions.
Michael, from a real estate agent's point of view and from your experience as well, can you give us some examples where the conveyancing process has not gone according to plan?
Measurements or times when the wrong property's been sold. That happens sometime with land, where you've got a certain volume and title which doesn't match up to the property that they think they've actually bought.
I see, right. Rex, how do we overcome that problem?
Look, it's all in contracts, so during the process you will identify that. A good conveyancer or lawyer will identify those issues before settlement and reach a resolution to it.
Before anybody signs a contract, they really should actually look at the measurements on title and go and actually measure out the title if they can do that.
That's a
physical exercise, or at least step out, because there are, especially around the inner city, when I say inner city, out to 10, 15 kilometres from the city, a lot of laneways and things that people have acquired, have fenced in but are not actually part of the legal title, and thus, you should be aware of that, because that leads to other questions of taking ownership of that, because it's a possessory title, you don't actually get the title, and you may have to actually make an application down the track for adverse possession, and it's important to get your possessory rights assigned.
And sometimes a car park might go missing when the process has finalised, and you see
yes,
there's
that's
no title for that.
Another thing, yes.
It's not missing, it's still there.
It's still there, but it's important to identify what your title entails.
In a real-life situation where exactly that situation has happened, what do we do? We've done the conveyancing, it's over, but you realise there's either a title is missing or not there for your...
This is why conveyancers can't deal with it. It goes to the Supreme Court and becomes a litigation matter.
I see, right. Once the conveyancing process has ended.
Yes. Even during the conveyancing process, if a dispute arises, it can go to the Supreme Court.